Good afternoon, everyone, and welcome back to KW Property Management Consulting's Best Practices monthly webinar for community associations. I will be your host, Tim O'Keefe, an executive director and partner with KW Property Management. Last month, we talked about Senate Bill 154 and its impact on community associations. Today, we want to go a little bit deeper on this bill, but also we're going to address other new legislation that has recently been signed by the governor, and we'll cover that today. We'll touch on those and other new bills that were signed into law, and we will get into your questions that you have. I'm sure there's a lot of them. We think today we probably had more questions sent to us in advance than any other webinar I've done. This is about number 55 for me. Let's get started by introducing you to our panelists today. We just have one esteemed panelist. We're very pleased to welcome Jeffrey Rembaum. Jeffrey is a partner with the law firm of Kaye Bender Rembaum, a very well-respected Florida firm that specializes in the practice of association law. So Jeffrey, welcome, and I'll let you do a better job introducing yourself.
Oh, well, thank you, Tim. It's a pleasure to be here. It's always a pleasure working with KW and the professional managers that you have. Kaye Bender Rembaum, community association law firm comprised of 21 lawyers with offices around the state in Broward County, Palm Beach County, Orange County, Orlando, Hillsborough County, Tampa. As well, 9 of us are board certified in this body of law, and one of my partners is board certified in construction law as well. You'd be hard pressed amongst all of us to find an issue of novel that we haven't had to grapple with in the past, though every day is a new exciting adventure within this body of law because it encompasses so many other bodies of law. It truly is fascinating. I author a column. If you don't receive it and you'd like to, it's called Rembaum's Association Roundup. And it's the community association news you can use here. You can see a copy of the website. You can get there from the KBR website, kbrlegal.com, or just by typing in rembaumlaw.com. Either one will get you to my blog. And if you have an issue happening at your association, you stand a pretty good chance I've written on it. Most recent article would be guns in the clubhouse. Can we prohibit them or not? If you want a copy of today's materials, we have the full-blown legislative update, a guaranteed cure for insomnia, but necessary and required reading to everyone who's in attendance today. Please go to kbrlegal.com or once again, my blog, rembaumlaw.com, and you will find in either location latest version of 2023 Florida legislative session. You'll find it on several places where you'll be able to simply click and download it to your own computer. You can then print it from there or just read it on your computer. But there are so many laws affecting today's community associations. We're just going to touch on the high points today. We only have an hour, and I think we would need a good 3 or 4 hours to really go in depth with all of the changes. But we're certainly going to cover those that are most important and on your minds.
So Jeffrey, if we hit all 3 hours today, then we would not have anybody suffering from insomnia tonight. So I'm glad we're only going to do an hour.
Including myself. I'll put myself to sleep. No, we try to make it exciting as best we can with the material the legislature gives us to work with.
And 2 things I'd want to point out is you talked about your offices around the state of Florida, which is important because we have listeners from all over the state of Florida that participate in these webinars. So Kaye Bender Rembaum is a good option for those looking for attorneys. And also, I am a personal user of the Rembaum Roundup. When I need to find something and I don't know where to go look, I typically go look at the Rembaum Roundup because I always find good information there. It's very insightful, easy to read, and a lot of good stuff. So I'm a big fan of your blog that you have out there. So thank you for your service to the community and in our industry by doing that.
Pleasure. It's nice to know I have at least one reader out there.
Yes, yes. Well,
right.
I'm sure some days I'm sure you can get your wife to read it, but at least I'm a loyal reader.
I appreciate that. Thank you.
All right. So for those of you that have questions today, please feel free to go to the Q&A icon at the bottom of your screen and you'll see the opportunity to send questions to us. And one housekeeping announcement I'd like to make, I often get asked by community association managers if these sessions offer continuing ed credits for the CAMs. Unfortunately, these webinars are educational purposes only, and they do not provide CE credits, but I'm sure Jeffrey does plenty of seminars out there that you can attend that give you CE credits. I know those are important to the CAMs that are listening today.
Hey, Tim, also, I would add that nothing you and I discussed today should be considered legal advice directed to any particular association, or even if we answer a caller's question, it still will be answered generally. And I'd be doing a disservice if I didn't then say you really need to follow up with your association's lawyer. Their opinions could be different than ours. And what we talk about today, there could be other facts. And we don't have the time to do the in-depth analysis that would otherwise be required. So this is just general information we're talking about today.
Very good point. So we got a lot to cover. So let's just get started with today's session. So Senate Bill 154, Jeffrey, is the glitch bill that was stepping in front of the bill that was put in place late last year, earlier this year.
What glitches? Isn't the legislature perfect?
They are. Senate Bill 4D was put in place in December, and then they came back in the session and cleaned up some of the bills. So my first question really for you, Jeffrey, is, in years past, we've gotten to the end of the legislative session and it's been kind of a dud when it came to association law. So this year, what kind of grade would you give the state legislature on addressing association law?
Well, they certainly were prolific. I give them an A for effort, a C for the final result, though the legislators involved with some of the homeowner association laws we'll talk about later, they might need to go back to summer school.
Okay. And, there's so much. I always think that the state legislature is there just to address association law business, but they got to cover a lot of different areas, all the different types of businesses that run throughout the state that have legislation. So we actually got quite a bit of attention this year in our industry. And so the C that you gave them for results is probably not bad because they need to clean some of these things up now.
Right. I think we need a glitch bill for the glitch bill in some regards, but at least they tackled some of the issues that we practitioners were facing in interpreting and trying to help our clients administer what they new laws are requiring.
Right. So we'll jump into it now. So Jeffrey, we're going to discuss the new bills in somewhat of an orderly fashion. We can start with Senate Bill 154, and then we'll move on to the HOA bills.
Sounds
good.
First thing,
Senate Bill 154, the big thing, and Philip asked the first question for me, and Philip in Singer Island, he wanted to know the difference between a milestone and a SIRS requirement. So let's start with milestone, and then we'll move on to and SIRS is SIRS. It stands for
Structural Integrity Reserve Study. Was that a softball?
Yes, it was.
Trick question. All right. So we'll start with milestone. We'll go to structural integrity reserve study. We'll talk about a couple other miscellaneous laws affecting condos. Then we can jump into homeowner associations and a few laws affecting them that came out of session. And then we'll talk about some miscellaneous potpourri, hopefully, and time permitting. Hope that sounds good to everybody. I always like to tell you what we're going to talk about, then talk about it. So with the milestone, we're going to have to talk about who can do the milestone. We're going to have to talk about the applicability. In other words, who has to, we have the experts that have to do the milestone report itself, but then which condominium associations and cooperatives have to do it. You're going to hear us today, Tim and myself, talk about condos over and over again when it comes to the milestone and the SEERs. Please, if you are a cooperative shareholder, these laws also apply to you, but we're not going to take the time to say cooperative after condominium every single time, but just know these laws apply to you as well. We're going to talk about who doesn't have to do the milestone. We're going to talk about when you have to have your milestone prepared. We're going to talk about once it's prepared, what kind of notice do you have to give to the owners? What's the difference between a phase 1 and a phase 2? Then we have post-milestone report duties, both the professional you've hired and the association. We then have enforcement issues. We have who pays, what happens if you don't obtain it, and then Tim's favorite, the manager's duty, with a little bit of cover the legislature has provided for the managers in this regard as well. And then we'll jump into the SEERs once we do that. That sounds like I just have an hour just talking about milestone, but I promise I will make it somewhat brief. Obviously, if you want a more in-depth analysis, go to kbrlegal.com, download the 2023 legislative update, And there you will find everything we're talking about today and so much more. So who prepares the milestone? Well, in last year's legislation, Senate Bill 4, that was a Florida licensed engineer or architect. And then it became very apparent, and in fact, there's a gentleman out there maybe listening now, Barry, hello, Barry, if you're listening, who keenly brought home to the legislature and so many people around the state of Florida that there simply weren't enough service personnel. There's not enough licensed architects and engineers to accomplish these goals. So who else can do it now? The Florida licensed engineer or architect is going to be the team leader. They're going to have the ultimate responsibility, but they now in the legislation have the ability to work with a team of professionals under their supervision. So now we have teams of professionals acting under the licensed engineer or architect, and that is spectacular. That's going to help a lot. I don't know if it's the full cure, but it sure should help. And as you'll see, there are even provisions for delay because maybe you've hired your engineer, but what happens if the engineer can't get to your project before the statutory deadline kicks in? And we're going to talk about that as well. Who does this apply to? Who has to do the milestone inspections? Let's start with residential. You need to be residential. If you're purely commercial, then you're not going to have these issues. Apparently, legislature is not as concerned with commercial buildings falling down as they are with our residential. 3 stories or more. Very simple. 3 stories or more, and you're residential, then you're going to be getting your milestone. If you're in a mixed-use building or a condominium hotel, well, then each party is responsible for the components of the building that they are responsible for. And once again, not applicable to purely commercial condominiums. It also does not apply to a single family, 2-family, 3-family dwelling with 3 or fewer habitable stories. So really if you think of townhome communities, that's really who is described in this particular exclusion. Now, what is the milestone looking for? Milestone phase 1 is a visual inspection. What are we looking for? We're looking for substantial structural deterioration, substantial structural distress or weakness that negatively affects a building's general condition and integrity. So that also was clarified in this legislation. The very important clarity was provided there. When do you have to have the milestone completed by? Well, by December 31st in the year in which the building turns 30 years of age based upon its certificate of occupancy. If a similar report was done within the past 5 years for local government, then that report may suffice for your milestone. Notice I said might suffice. If the building is this, there are some technical exclusions. I don't know if it applies to anybody, so I'm going to apologize in advance. Highly technical, but very important. If the building is 30 years of age before July 1st, 2022, then the milestone must be completed by December 31st, 2024. If it turns 30 after July 1st, 2022, but before January 31st of the year 2024, then you must comply with the milestone by December 31st, 2025. See, this is why you have to download the legislative update guide, because there is so much information, and I know I'm talking too fast for some of you to write all this down. So please, please, please download it and see where you fit in to this scheme. All right, now, what if the certificate of occupancy is not available? Well, then the dates are going to be up to the local building official. Remember, before we had some exclusions, right? It was 30 years based on the date of the CO. You had to complete the milestone, but then it was 25 years if you were within 3 miles of the coastline. Well, the 3 miles of the coastline is completely gone out of the legislation. It is now referred to as proximity to salt water. Again, local building department is going to play a role in this, but if you are proximate to salt water, then you have to have your milestone completed by December 31st of the 25th year from the date of the CO. Extensions can be granted by local government building officials upon a showing of good cause. What would good cause be? Things such as we've engaged our Florida licensed engineer architect but then at the last minute, they can't get to it because they're backed up, things like that. And then once you've completed it, now you're on a schedule for every 10 years and thereafter. So each and every 10 years, you are doing another milestone. Notice to owners. That's an important consideration. When the association receives notice from local government, now local government isn't necessarily obligated to inform the condo, but most of them are going to. And once you receive that notice, because even if you don't receive the notice, the statute still has deadlines by which you must complete your milestone. But if and when you do receive the notice from local government, then you have 14 days to provide that notice to the membership. So local government notice provided to government within 14 days. Phase one, phase two. Phase one of the milestone is completely visual. If you get it clear from your inspector, you're done. But if not, then you have to do a phase two. Phase two is destructive testing to see how bad things really are. You have to complete the phase one within 180 days of the notice from local government. And then if the phase two is required, then you at least have to provide status updates to local government within 180 days of submitting that phase one initial report. The architect and engineer, once they issue the report to the association, has a duty to not only provide the report to the association, they also have to provide it to any other owner that is not a residential condominium unit owner. I want you to picture a 50-story building, and I want you to picture the third, fourth, and fifth floors are excluded from the condominium itself. So we have a building, yes, we do. We have 50 stories, yes, we do. Are they all part of the condominium? No, they're not. In the back of your declaration of condominium, it describes the condominium itself. And a developer, if they're building a mixed-use project of one kind or another, they can exclude floors. And those excluded floors will still have to do a milestone at the expense of whoever is responsible for those floors. But what the law is making sure is that the expert that the residential owners board hired shares a copy of that milestone with the other owners in the building itself. For example, in that 50-story condo tower, those 3 floors might belong to a master association because they're common areas for other residents living outside of that particular condominium building. Really, it demonstrated, I think here, Tim, it really demonstrated some good thinking on behalf of the legislators that put this glitch bill together to capture that. That was really good. The association has several duties. There are 3 of them. Within 45 days of receiving the milestone report, it must provide it to all of the owners at their official address, be it within the association, or if the official address is in Nebraska, then you're sending it to Nebraska. If, once again, save a postage stamp, get your members to opt in writing to receive their official communications via email, and then you can email it to them. That would make sense given, how thick some of these reports might be. If your association is required to have a website, then you must post the report on the website, and it must be posted in a conspicuous place in the community. I think a glitch bill maybe for next year, Tim, might be how long do these things have to be posted on the website and on a conspicuous place on the property? We're not entirely clear on that from the legislation. We talked about the need to, if your phase 2 repairs, I'm going to jump backwards a little bit. The phase 2 repairs, you must commence the repairs within 365 days of the submittal of the phase 2 report to local government. All right. And let's see what happens if the association doesn't comply. What if the board doesn't get the milestone? Well, it is a breach of fiduciary duty, but only if the officers and directors willfully and knowingly failed to have the milestone. So it's not just that you didn't have the milestone by the statutory deadline. There may be good reasons for it. Maybe you're all set up for it and the engineer can't get to it. The architect can't get to it. Nevertheless, that certainly demonstrates that the officers and directors were not willfully and were not knowingly, right? They didn't act with intent to not have it done. They acted with intent to get it done. Therefore, there would be no violation under those types of circumstances. But if a board, officers and directors, if they willingly and knowingly fail to get the milestone, that is a breach of fiduciary duty. Breach of fiduciary duty can subject your own pocketbook to damages, so watch out for that one. Managers can breathe a sigh of relief when it comes to the milestone because their duty is to comply with the requirements of performing these inspections, but at the direction of the board of directors. So it still requires board action. And Tim, that's a real short overview of the milestone. I don't think I could make it any shorter. There's a lot of substance in there. So listeners, you have to go to kbrlegal.com. You have to download the entire presentation, put it by your bedstand, read a couple pages. You will nod off to sleep. Read a couple pages the next night, and you will get through all of the material before you know it. Tim.
Yes, so there are a couple of questions that we received about the milestone. So Sharon and Tamarack was asking, is the reserve study part of the 30-year milestone inspection? And how much?
Go ahead, I'm sorry, and I didn't know there was an and.
How much in advance of the inspection should the reserve study be done?
Well, it doesn't quite work that way. I need the listeners to think of the milestone and the structural integrity reserve study as apples and oranges, because that is what they are. The milestone is our building structurally sound? It's not looking to see if it's in compliance with building codes or anything else. Is the building sound? Structural integrity reserve study, or as we refer to it, the SEERS, is dealing with specific components and the need to have money to do deferred maintenance or replacement on those components at a later date. And I hope that helps our listener who sent in that question, but these are apples and oranges. However, we're going to talk about how you can do both together, but we're not quite there yet. So something for you to listen for in just a minute.
So let's assume you have a 28-year-old building and you've never had a milestone study done. And you're within 3 miles of the water. So you have to get a milestone.
Wait. It's not 3 miles anymore. Remember, that's in the glitch bill. It's no longer 3 miles from the coastline. It's if you are technical language here was a trick question for me, right? I want to say proximately located, but that is not quite correct. And I will give you the correct lingo in one moment. Keep going with your question, Tim, and I'll get you the correct lingo on that.
So let's just assume that it's 28 years and based on your location to water, it's time you have to get a milestone study.
Proximity would be the legal word for it. Proximity to salt water.
Right.
Then by December 31st of the 25th year from the date of the CO, who's going to tell us whether we're proximately located to salt water or not? More likely than not, our local government when they send us the notice.
Right. Okay. So we need to get a milestone study. That's the first phase, right? Phase 1 is a milestone. So let's assume I get a milestone study done and it comes back clean. Am I exempt from getting my SERS study done now and for another to the next period of time?
Oh, don't you wish that were the case, but absolutely not. These are independent. Can't make it any clearer for our listeners. These are independent requirements, mutually exclusive from one another, apples and oranges.
Okay, so now that we've distinguished the two, why don't we touch on SERS, the Structural Integrity Reserve Study, and what those requirements are for everybody that's listening today.
Absolutely. Please remember, I don't make the news, I only report the news as we begin to describe all of the requirements dealing with the Structural Integrity Reserve Study generally applied to residential. Again, we have clarity this year. Residential, just like with the milestone, right? Commercial didn't apply. Same here. If you have a pure commercial condominium, you're not going to have the Structural Integrity Reserve Study. I guess their lives, Tim, don't matter as much as the residential owners. Or maybe the government thinks that the commercial owners will be more responsive or will be more responsible. Or maybe they just had better lobbyists. I'm really not sure. But I think that on a personal note, many of these requirements should absolutely apply to the commercial condos, but there are full exemptions. So my personal feelings aside, If you're in a 100% commercial condominium, then you're not going to be doing the structural integrity reserve study. So generally applies to 3-story or higher residential condominium and cooperative buildings. I know we have some cooperative listeners out there. So and for the condominium owners, you all get to own your unit, right? The cooperative shareholder doesn't own their unit. What happens is the company itself owns the entire building, and the shareholder of the cooperative gets a proprietary use right. And that's how they used to build the big towers back in the 50s. They didn't have the condominium form of ownership, and that didn't come about until statutes described how you could buy a cube of air 50 feet up and 50 feet over, but that would have to be a conversation for a future webinar. We could maybe do that one day. So we talked about the Sears and who it applies to.
Thank you for talking. Thanks for mentioning co-ops, because Jerome in Hallandale wanted to know if these laws apply to co-ops as well. So thank you for that.
Absolutely, they certainly do. Let's talk about reserves generally before we jump into the Sears, right? I call them the sacrosanct 3, but it's really 4. Most everybody, when I talk to them about reserves, they can tell me roof replacement, pavement resurfacing, and painting. And they leave off the 4th one. Any other component with a deferred maintenance expense or replacement that exceeds $10,000. That's also supposed to have been in everybody's reserves. I can't tell you how many times that last one wasn't there. Now, let's change gears and talk about little g, the little g items of the Sears report. It's easy to refer to them. We need to name the components required to be in the structural integrity reserve study. Well, it comes from section 718.112, 2, and then a small little g, and then it lists the items. So I refer to the list as the little g items. Anytime today you hear me refer to little g, I'm specifically referring to the structural integrity reserve study components, which include the roof, the structure, which includes load-bearing walls and other structural members and primary structural systems, as defined in section 627.706. For all you legal statutory buffs out there that like to look things up, 627.706. So roof, structure, fireproofing, plumbing, electrical systems, waterproofing and exterior painting, windows and exterior doors, and any other item where the deferred maintenance expense or replacement cost exceeds $10,000 and the failure to repair or replace that component affects any of the little g items I just read. So roof, structure, fireproofing, plumbing, electrical, waterproofing, exterior painting, windows, exterior doors, any other item with a deferred maintenance expense of $10,000 that has that detrimental impact on the items above from the Sears, the little g items. The budget must include all of the little g items if you are subject to having the structural integrity reserve study. Now, if you're not responsible to maintain, I know someone's asking this question, Tim, I don't know who, it's got to be on your list. We don't maintain the doors and windows at the association. The owner does. Do we have to put it in our Sears? That was a big glitch that got fixed this time as well in this legislation. And the short answer is you only have to have it in the Sears if the association is responsible for it. If you're not responsible for it, then it doesn't have to be in the Sears. And I know a lot of boards are going on that one, because why would you want to have to include the component for windows when the association wasn't responsible for replacing the windows in the first place? It didn't make sense, but in last year's legislation, that was the case. This year's legislation, it got straightened out. Now, before we go much further, Tim, let's talk about the exemptions to who doesn't have to do the Sears. So buildings less than 3 stories, once again, single family, 2 family, 3 family dwellings with 3 or fewer stories. Again, think of townhomes. Any portion of the building not subject to the condominium form of ownership. So once again, I want you to picture that 50-story building where floors 3, 4, and 5 are excluded from the condo. Any part of those floors would not have to be included in the Sears. Any portion of the building that is maintained by someone other than the association. So that has been clarified in the legislation. So if a portion of the building is maintained by someone other than the condominium or cooperative association, then that component does not need to be in the residential condo structural integrity reserve study, and once again, commercial condos. So those are the 5 exceptions. Now, we'll talk about when you have to have this completed by and how to tie it into your milestone. So if the association exists on or before July 1st, 2022, and it's unit owner controlled, then you must complete your SEERs by December 31st, 2024. But if your milestone is required to be completed on or before December 31st, 2026, then you can do both at the same time with one caveat. The caveat is the SEERs still has to be completed by December 31st, 2026, and then every 10 years thereafter. Okay, what type of inspection is the SEERs and who's doing it? Once again, it's similar to the milestone phase 1 in that it's a visual inspection. So it makes perfect sense. My gosh, if you are scheduling your milestone, schedule the SEERs. Just do them in tandem if you can. Now, who can do this for you? The Florida licensed engineer, the Florida licensed architect, a person certified as a reserve specialist or professional, reserve analyst specialist by the Community Association Institute or the Association of Professional Reserve Analysts. So that should help with the backlog the engineers and architects would have in getting these SEERs done. So it's any person certified as a reserve specialist or professional reserve analyst by CAI, the Community Association Institute, or the Association of Professional Reserve Analysts. Tim, we must be doing something right because I notice nobody's dropping out of the seminar as yet. So to all of our listeners, thanks for hanging in there with us. We know some of this material is tedious and difficult, but again, there is a full guide so you can fully review everything on your own at your leisure later. You can annually, sorry?
Question that came in.
Oh, well.
For milestones. Would it be safe to conduct the milestone study before the 30-year mark for the property?
Depends. You'd want to do it within at least, 5 years of the deadline date. Anyway, you could certainly do it. Whether you'd want to coordinate with local government, you wouldn't want to do it and then find out you did it 1 year too early and they're going to make you do it again. So little coordination there is probably important. But let's stick with the SEERs, and we can jump back to milestone later, but I don't want to confuse our listeners by hopscotching too much around. Okay. Annual updating. So you can take into account repairs you've made during the year when you're preparing next year's budget. So just bear that in mind. You take into account any changes in the estimate or the extension of the useful life of the component caused by any maintenance you may perform. So maybe somebody has a flat roof, and I saw this new material. I don't think it's that new anymore, but it's this big, thick white gel you can put on the roof. Ordinarily, you might have needed a new roof and you were saving for it, but you use this new product, you saved half the money, and it has a 30-year life. 30-year life. Wait a minute. A 30-year life. We're going to talk about what happens when a component has a 30-year life and its impact on the SEERs in just one moment. You can also take into account now, finally, inflation in putting your structural integrity reserve study together, because we know that $2 widget is not going to be $2 in 15 years when we need to go buy it. So you can take into account the inflation. Inside the SEERs will be the identification of each item. It will state the estimated useful remaining life and replacement cost or deferred maintenance cost, and it will provide the reserve funding schedule. That's all very important information. If the useful life is not ascertainable, then it's up to the professional doing the report to include it or not. If the useful life, let's go back to that roof with a 30-year life, if the useful life is greater than 25 years, then it's not even required to be in the SEERs at all. Those are two pretty big substantial changes, I think, from last year, right? So if you can't ascertain the useful life, it's up to whoever's doing the report for you. If the useful life is greater than 25 years, it's not required to be in the structural integrity reserve study until it has 25 years or less life left to it. All right. You can have an alternative funding method, but in order to do so, you need the Division of Condominiums approval, and your association must have at least 25 condominiums. So think of it this way. You could have one building, and everyone thinks of one building as a condominium, but I could have 5 buildings, and they could all be subject to the same singular declaration of condominium. How many condominiums do I have? 1, even though there's 5 buildings. Now, what if I have one association that has 30 buildings, and each building has its own declaration of condominium? That's what they're referring to, the multi-condominium itself. So one association, one set of articles, one set of bylaws, but you have 25 or more sets of declarations of condominium. Whew. Okay, they don't set them up so much that way anymore, but the only ones that can do that alternative funding and get the permission from the division are those that very squarely fit into that little box. We're going to talk about using reserves for a different purpose. We're going to talk about pooling the reserves. We're going to talk about publishing the structural integrity reserve study. We're going to talk about obligations of sellers when they're selling their unit, and the failure to obtain the structural integrity reserve study. First, can you use the reserves for a different purpose? Well, if you have the Sears, you may be able to, with consultation of your association's attorney, only within the Sears items, use money for a different purpose. Makes sense? So you're straight lining all the different components, and you have extra money in electrical, you need it for plumbing. Well, a vote of the owners may get you there, but it's going to be, remember, it used to be a majority of a quorum when it came to reserves and all that. From now on, just think of it as a majority of all. It's no longer a majority of a quorum. It's a majority of all membership interests. So bear that in mind, please. Extremely important. You cannot use money reserved for the little g items and then decide to use it for another purpose outside of the little g items. That is not permitted under the law. You cannot do that. All right, everybody is clear on that. All right, good. So if you have reserves that are non-little g items and you want to use that money for a different purpose, you will be able to do so. But once again, that's a vote of the owners, a majority of all. What about pooling? Pooling, that's a very complex conversation, and we'll touch on it, but I'm directing all of you, as I always do anyway, but you got to talk about it with your attorney. They may feel different than the way Tim and I talk about these things. So many different opinions, but generally speaking, you'll be able to pool. But what you can't do is pool outside of the little g. So only little g items can be pooled together. And then anything outside of little g can be pooled together. It's so important as to when you are going to start the pool. I'll give you some examples, but it gets really complicated, which is why we can't get too deep into it. But let's say you decide to pool your roof, structure, and fireproofing together. And okay, fine. And you do it on day 1. So you've never had the reserve. You're creating the new structural integrity reserve, and on day 1, you pool it. Well, consensus of thought is that if you're doing it on day 1, you probably don't need a vote of the owners, but you don't want to be a test case either, because what if the division comes out and says, no, you needed the vote to do that? So different attorneys feel differently about that one. But what about moving money? Because we have a new reserve system, right? We've got the structural integrity reserve study, roof structure, fireproofing, electrical, waterproofing, plumbing, windows, doors, any other component, blah, 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 that costs greater than $10,000 that affects those items up above with replacement or deferred maintenance. What if you're moving money from last year's reserves? This is the first year of your structural integrity reserve study, and you're moving the money from something different. Do we need a vote of the owners to do that? Probably so. So on the one hand, you might not need a vote of the owners to set up the pool, but then you might need a vote of the owners to fund the pool. And the combinations and permutations, when I sit there and try to think of them all, I can drive myself insane trying to think of all the different situations that all you nice folks out there listening are going to run into. So for the time being, pooling is a case-by-case basis. Get with your lawyer, describe what you want to do, and they will tell you whether you need the vote of the owners or not. But if you do need the vote of the owners, it is no longer a majority of a quorum. It will be a majority of all owners. Everybody's clear on that? Anyone have questions on that? Seeing none? Perfect. All right, good listeners today. Uh-oh.
For you on that.
Okay.
So, but just for funding reserves, so there's requirement that by December 31st of 2024, budgets need to be developed so that properties are going to be fully funded. So what exactly does that mean to be fully funded for reserves?
All right, good question.
The end of 24 in your 2025 budget.
What does fully funded mean? And there's a lot of misconceptions in the marketplace on the term. I want to preface the answer with Florida looks at this term differently than other jurisdictions. So fully funded doesn't mean that if the water cooler on the top of the building, a $500,000 expense, right? Do we need to have all $500,000 to be fully funded? No, that is not what the term means. It doesn't mean we have all the funds necessary for the deferred maintenance or for the replacement at this time. It means we are on target to have that money at the appropriate time. I'm going to make it simple. We have a $100 item. It has a 10-year life and it has to be reserved. How much do we have to put away every year? Tim, we're in year one. It's $100. How much do we have to put away this year? Go ahead, go for it.
$10.
Excellent. Now we are in year 7. We've never reserved for the item before. The legislature says we have to reserve for it now. How much do we have to reserve in year 7 to be fully funded?
$70.
That's correct. See, Tim gets it, everybody. So many people I answer that question to and it comes back at 30. I'm not sure where they're getting it from, but I hear that more often than not, but that is correct. So if you're going to be fully funded, it's how many years do we have in the useful life of the component? How much money do we already have set aside? How much are we going to need? And then you do the math. So if it's a 10-year life and a $100 item, year 1, $10. If we have to go in year 7, then that amount of money for that first year in year 7 is going to be that $70, but then 8, 9, and 10 can come back down to the lower level of $10.
Right,
All
so
right, makes sense?
Steve raised his hand and said, how come it wasn't $25?
Because it's 70. That's why. Tim, you may have a better answer.
Because you need to fund $10 a year for the first 7 years, which would get you to $70. Means you have 3 years left. You have to fund, if you continue to fund $10 for the last 3 years, that would get you the $100 you need. But in that useful life of that air conditioning unit expires, if you have to replace it, hopefully it's maintained. If you have a good management company, it's maintained properly, it might last you 13, 14, 15 years. And then you can continue to fund for it, but it's going to just make it cheaper the better you maintain your equipment. So that's important as well.
Outstanding. So what if we have a reserve for the roof and we want to use some of those monies for plumbing? Because we have something that came up on deferred maintenance, but we don't have enough in our straight line plumbing. What do? We can do that, right? Because it's in the little g pool. So as long as you're using money from one little g component to another, is you get the owners to consent by a majority of all. I keep saying this because I really want to drive this point home because it's been so different for so long. You can only use monies for a different purpose within little g. And again, only by a vote of the membership, which is going to be a majority of all the members, not a majority of who shows up at the meeting, a majority of all of those membership interests. Okay.
So can you...
Oh, that applies to Tim, by the way. Let's say we have a reserve item for something not in the little g items, and you want to use the money for a different purpose. Same thing, majority of all.
So this is a really great question that Gina was asking. Does having a line of credit count toward fully funding reserves?
Not at this time. A line of credit wouldn't do it because you don't have it in the reserve. But if you were to borrow that money, take it from the bank, put it into your account for that reserve. Now it's funded.
Can a contingency loan be used toward the funding needed for coverage? It's kind of the same question, right? It's just
kind of the same question. Not at this time would be the answer. I'm a proponent for that. I'm a proponent that the legislature adopt legislation so that even if the governing documents require a vote of the members to borrow, when it comes to structural integrity reserve study requirements, milestone requirements, things like that, that the board should have the power, notwithstanding the governing documents in those situations. And it sure would be nice to allow for a existing line of credit to substitute in, but you'd actually have to take the money and enter into that loan and start paying the interest, put that money from the bank into your account in order for that money to count.
So a little bit off the reservation here, but somewhat consistent with reserves. And I know I get this question asked a lot, or I try to consult people on this question. I'm sure you hear it a lot too, Jeffrey, but Philip is asking, can you borrow money from the reserves for insurance premiums and pay it back with sufficient interest?
No, stop. No, I hear that. I have to mind attorney-client privilege and such. But from time to time, I am asked, hey, we borrowed money for reserves. And I'm being told this rather innocuously as like part of a story about something else. And they're talking about funding, and they start talking, and the board starts talking to me about, well, we borrowed the money from the reserves and we have to pay it back. No, you can't borrow. There's no such concept as borrowing from reserves absent permission of the membership, which now requires what? Majority of all members approving. And if it's in the little g items, you can only use that money for other little g items with the vote of the membership. And outside of little g items, you can use that money for a different purpose as well. But again, a vote of a majority of all to accomplish the goal. And if anybody out there is listening and they borrowed from reserves, put the money back tomorrow, please.
Yeah, and that means a lot of times you have to special assess. Actually, unknown property that I'm not saying exists, but I might have a meeting on Monday night to explain why they've been running a 6-year deficit, and they've been borrowing money to pay, and they couldn't understand why they're not short. They're short on cash, but not short on paying their bills. It's like, well, somebody should have instructed you. We shouldn't have taken you to hire us this week to come in and explain to you that you can't do what you're doing. So we're going to clean it up. We're going to get them right on the right path. But, you know, those are kind of things. Ask your attorneys, please, if you can do those types of things, because your attorney should give you, it maybe sometimes I hear, well, yeah, it's okay to borrow the money as long as you pay it back within the same fiscal year, because
nothing in the law that supports that.
Sorry. When you're on it. That is an answer that you hear sometimes. It's the wrong answer, but you do hear that sometimes.
That's really scary. I tell you what, they won't work for us very long.
Yeah. Jeffrey, we only have like 10 or 12 minutes to go. We haven't touched the HOA side of the world. You want to jump into that?
Oh, so much good stuff. Unit owners selling their unit have to provide a copy of the structural integrity reserve study to the buyer, but there's no similar requirement that the association provide a copy of the structural integrity reserve study to all the owners. The only requirement in the statute is the Sears has to be published on the association website if in fact you are required to have a website in the first place. Once again, if you don't obtain the Sears, it's the same standard as the milestone, knowingly and willfully. So there is some protection there.
So just to clean up one of the topics that we talked about, the last question I see on this is if we had a specific line item that had a 10-year life, since we were talking about a cooling tower with a 10-year life, can we wait to fund that line item and assess at the 10-year mark? In the past, yes, but not with the new law. That's what we've been talking about, right?
That would mean they waived or reduced, and you no longer have authority once the Sears go into place, right? Once the first year, you have to have it December 31st, 2024. No, there's just no concept of waiving or reducing reserves out there. Zero.
Right.
So you are funding every year.
If you're over 3 stories. A question that came in from Bob in Boynton Beach. Can you waive reserves? Can you still waive reserves if you're in a 2-story building?
Waive or reduce non-little g items. That's what the question boils down to. Really doesn't matter the size of the building. If it's a non-little g, or it could be, I guess, a little g item sort of in the two-story building. Talk to your lawyer, though. They're, I'm trying to remember that one. I want to take a pass on that one because I don't like giving out the wrong answer, and I want to think that one through. So maybe by the end of the lecture, I'll give you the answer on that one.
Okay. So,
In fact, get that fellow's email address for me as well, if you would.
okay, I've got it. I've got that.
Good, good. So I can argue in my head, I'm arguing both sides, and sometimes when I do these lectures, I discombobulate and I can argue both sides of an issue, and that's really not what we want. We want the definitive answer here.
So this year, the state legislature spent a lot of time on HOA laws as well. So we have, you and I, we call the HOA Bill of Rights. So can you fire through the Bill of Rights, and you got about 10 minutes left, and try to address the Bill of Rights and some of the miscellaneous statute changes that came up?
Absolutely. This is one of the most monumental changes, is HOAs are now required to identify all agenda items. It may have been a requirement in your governing documents to list the agenda items, but the law only said you had to notice time, date, and place. Now, similar to condos, if you're going to talk about it, you need to designate it on the agenda. So that's a pretty big change. Another big change, notwithstanding anything in your governing documents, any HOA member can store any item on the lot, so long as not prohibited by government, that is not visible from the parcel frontage or the adjacent parcel, not limited to artificial turf, boats, flags, and RVs. So what I need everyone to think about is the legislator who got upset at his HOA because he wasn't allowed to bring his boat onto his property because it was visible and they said no boats overnight. I suspect this particular law came from a real world situation where someone got upset and stuck it in the bill. Problem with this is, even if you can't see it from the right of way, even if you can't see it from the adjacent lot, if you're on the lake, everybody else on that lake is seeing it too. So there's a huge glitch with that particular piece of legislation that needs to get cured. Deposits, big one. Don't get caught in the trap on this one. Deposits must be segregated from operating funds.
Any kind of deposit.
Any kind of deposit. Really, I think what we're talking about, architectural, fees the association charges as deposits for one reason or another. Maybe it's a rental deposit, maybe it's the architectural, application deposit, but all these deposits need to be segregated. Tim, you're the accountant CPA. How do you define segregated?
You have to have a separate account. I'm not a CPA. I'll say.
Oh, I'm sorry. Okay, I thought you were.
I have many partners that are, but for me, it means you have to have a separate account, put the funds in, and you can't put them in the same bank account that you have your operating account with. That would be commingling. It cannot be commingled. So you have to have a separate account.
And I'll tell you something, another question we get with deposits is, what do we do when people don't take their deposits back? Well, if you don't have a policy in place, you're supposed to, the technical word is escheat that money, give that money to the state of Florida. So you should work with your manager and your association lawyer to develop a rule and policy in place as to what happens to non-return deposits, which can then go to the association rather than the state, but you have to set it up in advance, not afterwards. There are new grounds for immediate removal of an officer or director dealing with forgery of ballots, theft, embezzlement of association funds, destruction of official records, willful failure to provide official records, and obstruction of justice as well. There's new conflict of interest disclosures. There are new criminal penalties. There are new kickback standards, if you will, that we should certainly discuss, if not today, then another time. But I want to jump into something that affects all of us, which would be fining, given the limited time we have left. Clarified in the legislation, remember, the association board sets the fine. Then the offending member gets a notice not sooner than 14 days prior to the meeting when the fining committee is going to meet. Fining committee meets, and anything they say or do other than affirm what the board did equals a no. So if the board said $50 a day and the committee felt bad and said 25 a day, that equals a no, and that owner won't have to pay anything. What the law clarified is a couple things. Number one, of course, the offending member gets that 14-day notice. But that 14-day notice has to include the alleged violation, the action needed to cure it, if applicable, along with the date and location of the meeting. If the offending member wants to appear electronically by telephone or some other method, the association is going to have to accommodate that so they can appear. Clarity is provided that it's the majority of the committee. It's not the unanimous consent of the committee. If you have 3 people, do they all have to be unanimous? No, 2 can make the decision, 2 in favor, 1 against. So we do have some clarity there. And the fining committee must meet. It's not optional. I can't believe they had to legislate this. Some people out there actually thought, Tim, that it was optional if the fining committee could meet if the offending member didn't say he wanted to appear in front of the committee. Doesn't work that way. The committee has to meet in order for that fine to be levied against the owner. So that is a very, very important item that needs to be discussed. Okay, not much time left. Can I jump into a potpourri?
Please.
Okay, potpourri. Statute of limitations on negligence has gone from 4 years down to 2. Any good insurance reasons, right? We have all kinds of insurance legislation that could be the subject of another hour that to really jump into. But essentially, legislature made extreme efforts to stabilize the insurance market. It's not as though we're going to see carriers running into the state, but I think the goal was to stop the bleeding. And I think the legislature did that. One, they did all kinds of laws. We'll talk about a few of them, but one of them that made it so much harder for recovery is dropping that negligence statute of limitations from 4 years down to 2 years. If you are greater than 50% responsible for whatever the ailment is that you're suing as the plaintiff, you recover nothing. Florida used to be a comparative negligence state, so that once it was affirmed that you were hurt, then the blame was apportioned, and maybe you were 10% responsible, and the other guy was 90% responsible. So then if you recovered $100, you would only recover 90. But now the law is such that if you're greater than 50% responsible, you don't recover anything. And that may help, Tim, with some of the things you and I have to deal with regularly, like a HOA member not watching where they're walking, trip and fall on the sidewalk. And if the sidewalk panels are greater than, a quarter of an inch between panels, then there can be liability, which is absolutely ridiculous. But now apparently there's an argument that the homeowner is responsible for watching their own 2 feet. And if the jury thinks they're greater than 50% responsible for causing the accident, then that owner will not be able to recover anything. We have a construction defect statute, huge change, 7-year statute of repose. Everyone's familiar with the statute of limitation. Statute of limitation is the time in which you must bring a lawsuit from the time you knew or should have known. Okay, the time you knew or should have known. So let's take a construction defect. Let's say the defect occurs in year 6, and we bring the lawsuit that same year. Well, did we bring the lawsuit within 4 years of the time we knew or should have known? We did. Statute of repose used to be 15 years, then 10, now it's 7. What it does, the statute of repose says, notwithstanding the statute of limitations, even if you're timely there, if you are beyond 7 years from the date of the temporary CO, you cannot bring your claim, period, end of story. So that can be harmful, I think, to some of the taller buildings when they don't discover their latent defects until much later. We have new workforce housing legislation that provide local government cannot stop a builder from building workforce housing inside industrial and commercially zoned districts. That is huge. We have a huge problem in the state of Florida, right? If you want to, workforce housing, by the way, is not Section 8. I hear about people misconstruing what workforce housing is. And I've actually seen members protesting workforce housing. Really? You want to stop the paramedic, the nurse, the school teacher from having a place to live close in town rather than having to drive from St. Lucie to West Palm? Because that's what you're doing when you're protesting workforce housing. Workforce housing is the price of the property is determined by government. So the builder has to build it within certain price points. Obviously, the profits may not be the same, but they're able to provide housing for workers, people that are supporting our community. It's not people that are Section 8, if you will, type housing. It is not that type of housing at all. And if you think so, then you're under some misconceptions. So in any event, now for infill, anywhere in an industrial or a commercially zoned district. Bad faith claims against insurance companies got a lot harder. First, you have to go to the trial court, and the trial court has to find there was a breach of contract before you can bring the claim. So all sorts of things. You can't assign your lawsuits anymore to builders. You can't give him your insurance benefits. When I say assignment, I mean you can't assign the insurance benefits to the builder. In the old days, you would have a roof problem. The roofer would say, hey, don't worry, you don't have to pay me anything. Just assign the claim to me. And they would, and then they'd get some money from the insurance company, and then they wouldn't be happy with the amount of money they got. If they got so much as $1 more from the litigation, then all the prevailing party attorney's fees were paid as well. So that has been eliminated from the legislation. So you can no longer do those types of things. So basically, all these things were done to help stabilize the insurance market itself. Whew. Wow, Tim, we are 4:01. I could keep going, like I said, in depth for 2 more hours. I apologize for we don't have more time for our listeners.
A couple of things that flags are an issue. So talk about flags, because that was part of the Bill of Rights. There were 2 issues relative to flags about what's allowable and how many you can fly.
You can fly up to 2 off the enumerated list, one being the United States flag, one being one of the other flags, such as armed forces, and things such as that.
The 2 new flags that were approved this year were the state of Florida and first responder flags. So those are allowable flags to fly. You can fly too.
We had the state of Florida, Tim, before.
The law says it was
that came
this
in.
year, so
Either way, I'm a fan of flags, and I think good. Show some patriotism.
I'll end with this question. So, because Paulette was asking this from Boca, she said, with regard to the new rules on issuing violations on the back of homes, what if the backyard is visible by other neighbors, or if viewed across a large lake can be seen from common areas or by multiple homes? Can an association still cite violations?
Yes, short answer is, generally speaking, I think the answer is yes. Remember, the new legislation says, notwithstanding what the rules might be of the association, you can bring your RV to the lot, even if it says no RVs, so long as it cannot be seen from where?
The road, the front of the house.
Or the adjoining lot. But again, what about from across the lake? So there really isn't clarity. Can you then still fine them for putting the RV behind the house? Well, are you going to be able to put the RV behind the house in the first place? Probably not. So let's make it a boat. Can you bring the boat behind the house? How are you going to get it there? I guess maybe through the gate, because you have an extra wide gate. Now everybody sees it on the other side. Well, the loss, it's going to be interesting. There's going to have to be some test cases. Hopefully before they're brought, this law will get straightened out one way or another. I think it's a bad law to begin with. Also, what about applicability of some of these? We didn't even get time to talk about applicability. What can the legislature impair our existing contracts? The declaration is a contract between the association and the member. The real deal contract. When you close on your house, boom, it's as if you signed on to that contract. We have constitutional protections, both United States and state of Florida, against governmental interference in our existing contracts. So is there a good argument to be made that that law doesn't even apply to any association in existence prior to the date of its enactment? You bet there is, unless that declaration has what we refer to as Kaufman language in it. Kaufman language is sort of a sentence that says, as the law changes, it's morphed into our governing documents as if we always had it there. Absent some type of provision like that, then there's good argument that that law doesn't even apply to a homeowner association. So again, attorneys are going to disagree on the applicability, and it's going to have to get resolved in the court system or through future legislative enactments. Great question, though.
Okay, so I'm going to put a bow on one other thing. Our friend Barry provided us an answer on the 2-story condo. So the 2-story condo can waive any required reserves with a majority vote of unit owners. They are not subject to SERS and have no SERS components.
Correct.
With the vote, unit owners can waive required reserves for the roof, painting, paving, and items of
the traditional other items
exceeding $10,000.
And I'm hoping they include they begin to include now those other components that have that deferred maintenance cost or replacement cost of greater than $10,000. But remember, the vote is going to be not a majority of a quorum, but a majority of all. That is the critical takeaway. So any non-reserve, any non-little g item is what we're going to say. We can go back to that definition of it. Then there's opportunity to do so.
All right, so one more quick reminder, Jeffrey, where can we find this information at Kaye Bender Rembaum? We covered a lot there, and I agree with you. Print it out or go to the website and start reading, and you'll get to understand a lot more what's happening there.
abrlegal.com.
Okay, and there it is, legislative update. We saw it. All right, so we had a great session today with Jeffrey Rembaum.
Thank you for
thanks for
listening,
helping us
everybody.
better understand these complicated laws. I believe our listeners got tremendous value from today. I certainly hope they did. We appreciate all the questions asked. Sorry we didn't get to all the questions, but we tried to get to the big buckets of questions. So today's session is recorded. If you want to go back and listen to it, anybody who's signed up today will get a message by tomorrow from us, an email that has this recorded session. Feel free to share it with your friends and other board members that may not have been able to participate today. It's also available at the kw.com website. You can go to kwpmc.com and our YouTube channel. You can find it at KWPM TV. We look forward to having you join us again next month as we continue to talk best practices for community associations. Typically the third Wednesday of the month. We did a little bit of a shift this month to accommodate everybody. So we appreciate your time from 3 to 4 o'clock. It is the summertime. So from all of us at KW Property Management Consulting, please be respectful to your neighbors. More people are home, people are traveling. Stay healthy and be kind. Thanks so much, Jeffrey, for your great insight. And thank you for all our listeners. Have a great rest of your week.